contract was merged into this new contract, and that there was no old contract for the court to, for the county to revert back to, as they say in the minutes. The facts of the case: November 13th, 2012, there was a resolution that authorized the execution of this agreement. In fact, it directed the chairman of the Board of County Commissioners to sign such an agreement, which he did on November 27th, 2012. That's at record 25. On December 12th, there was a motion to reconsider the signed agreement after the contract had been signed, of course, under Collier County's version of Robert's Rules of Order. Now, there had been a change in commissioners, as Judge Hart had pointed out, and this motion was put on the next regular agenda. The next regular agenda was January 9, 2013, and the board passed a resolution rescinding the signed agreement, the signed amended and extended contract, and what they contend is revert back, or putting Mr. Curry in place with a contract that was to expire September 30th, 2013.
So at that point, the fact that he continued to work could not operate as an estoppel, because he was not without a contract at that point. He was, in fact, he was bound, even under giving effect to the reconsideration, he was still bound by the September 10 contract.
Mr. Curry, yes, sir, that's exactly right, Judge. Mr. Curry had signed a written contract that said that he would work for Collier County as its executive director until September 30th, 2015.
So there was no basis, based on his continuing to work, for the county to assume that he didn't have a gripe about the rescission.
That's correct. When you look at the requirements of estoppel, Mr. Curry had to have done something that caused them to rely on it and change their position. They rescinded a contract that was in place, and on September 30th, 2013, they just quit paying him, so he quit coming to work. I think probably the most important document in the record for Your Honors to consider is at record 217, and that's the ordinance itself. This ordinance explicitly allows Collier County to reconsider and rescind any matter, that's the first two words in the ordinance, any matter, 2 regular meetings, or 2 months, in this case, after they pass an original resolution. I would ask the court to focus your attention on sections 2A, and this is what I would sort of refer to as the frolic and detour from Robert's Rules. A commissioner can make a motion to, they call it reconsider, but it's really to rescind is what happened here, at a meeting following the meeting in which the ordinance was passed. Now, when they say the word following, they don't mean the word next. What they mean, following, means following under the current version. A motion to reconsider can be made 2 months after the original decision was made. If Your Honor would look at 2B, you can see that. I've got a blow-up of a record of this provision. I've shown it to Mr. Woods prior to. This is the important section of the resolution right here. And quite frankly, Your Honors, I believe that's where the county goes awry in using this reconsideration ordinance. There are 3 significant problems with what they do in this reconsideration ordinance. One, the reconsideration ordinance allows it to, a future motion for reconsideration, rather than requiring the motion to reconsider being made at the same meeting and acting on it then. Now, while Robert's Rules may require or requires that all action on the resolution be suspended until the reconsideration motion is resolved, Collier County actually authorizes its chairman to execute a written agreement. And thirdly, Collier County does not limit its reconsideration to legislative issues, as one might expect. Rather, it interprets all matters to include contracts, which is specifically excluded under Robert's Rules.
Yeah, but I mean, they're not bound by Robert's Rules, are they?
No, no, sir. No, sir. They're not bound, but they're bound by contract law.
Right.
And while Collier County claims it has contractual immunity based on its reconsideration ordinance, that's not what the ordinance says. There's no word in that ordinance whatsoever about what happens when Collier County breaches a contract. It can breach a contract like any other citizen, but that doesn't mean it gets contractual immunity for doing so. And in fact, the ordinance recognizes the potential of a lawsuit as a result of its reconsideration. If you want to have under this ordinance, under 2B, a commissioner can make a motion after the resolution and have it brought up at one of the two next regular meetings. To do that, he's required to send a notice to the county manager. Got to send a notice to the county manager. And the ordinance itself recognizes the potential of liability, because what it says, the purpose of this requirement, that is the notice to the county manager, is to allow the staff to advise the board of the legal or other ramifications of its actions. So the drafters of the ordinance recognize there may be some difficulty if they revoke, rescind written contracts. Now, presumably that occurred in this case, and either the county was given bad legal advice or was given good legal advice and chose not to follow it. Doesn't make any difference. Mr. Curry had a written contract that the county breached, and he's now entitled to a severance pay. Now, Judge, this is not an isolated incident. If the court were to look at the record 146 through 147, you will see 10 instances in the same day where Collier County reconsidered contracts. Now, if this court were to accept Collier County's position, it would mean that Collier County's written word is no good. And if Collier County can revoke a contract, written contract, without liability, then nobody's going to want to do business with Collier County. I would ask the court to affirm the trial court on the summary judgment, and also under the authority of the Ferry case, to affirm the award of attorney's fees. Thank you, Judge.
Okay, thank you.
Just very briefly, Your Honor, obviously the Board of County Commissioners has control of the interpretation of its own rules, et cetera. The case law is very clear on that. The thought that Collier County can just go back on its word is not accurate either. Collier County can rescind within 2 meetings. After that, it is bound, and they have to follow the proper procedures.
The contract itself doesn't say anything about that.
No.
The vote is to authorize him to sign the contract. He signs the contract. Now you got a signed contract.
Correct.
So then later on, the board says, oh, we decided not to authorize you to sign that contract. The horse is out of the barn. Mr. Curry is performing.
But the ordinance gives the Board of County Commissioners the ability to change that. And Mr. Curry knew that.
Whatever he knew or didn't know, the question is did he have a signed written contract on that day? Yes, he did. Authorized. County later decides to deauthorize that. I don't know that that changes the status of that contract.
The ordinance allows the board to reconsider any matter,
Right.
matter, and that includes contracts. And everybody who comes in front of the board and contracts with the board is aware that or is charged with knowledge under the law of that fact, so that they should know that until those 2 meetings pass, their agreement with Collier County could be rescinded or changed. And that's one of your requirements. If you're going to deal with a county is not a private party. There are particular rules with regard to dealing with government entities, and lots of special rules with regard to contracting and public bidding, et cetera. It's a unique entity, and you need to know the requirements if you're going to enter into a contract with the county. So I think under the circumstances raised with regard to the original contract, the extension coming out of January 9th with a revised contract, and Mr. Curry's continued employment all raise fact issues for which summary judgment is inappropriate, and that this matter should be remanded to the trial court based on Collier County's estoppel defense. Thank you.
Okay, thank you both. We're done.
One more.
Yeah, we have one more.
No, sir, I don't.
Yeah, we're done. Thank you.
Yes, sir.